Article 13, we go to mitigating circumstances. Mitigating circumstances are those which, if present or attendant in the commission of a felony, would serve to lower, reduce the imposable penalty. There is a reduction in the imposable penalty because there is a diminution on the elements of voluntariness. There is a diminution either in criminal intent, freedom of action, or intelligence, the elements of voluntariness. This is a frequently asked question in the bar. Distinguish privilege mitigating circumstance versus ordinary mitigating circumstance. An ordinary mitigating circumstance can be offset by a generic aggravating circumstance, whereas a privilege mitigating circumstance cannot be offset by any aggravating circumstance. Second distinction, an ordinary mitigating circumstance, if not offset by generic aggravating circumstance, would serve to lower the imposable penalty to the minimum period of the penalty prescribed by law, whereas a privilege mitigating circumstance would serve to lower the imposable penalty by at least 1 or 2 degrees. So those are the distinctions: ordinary mitigating versus privilege mitigating circumstance. Under Article 13, the following are the mitigating circumstances. First, those justifying circumstances or exempting circumstances when all the elements necessary to justify the act or to exempt the offender from criminal liability in their respective cases are not attended. Otherwise stated, we have incomplete justifying circumstance or incomplete exempting circumstance. When all the elements necessary to justify the act are not present, we have incomplete justifying circumstance. When all the elements necessary to exempt the offender from criminal liability are not present, we have incomplete exempting circumstance. This incomplete justifying or incomplete exempting can be considered either as an ordinary mitigating or as a privilege mitigating, based on the following rules. First, if majority of the elements necessary to justify the act or to exempt the offender from criminal liability attended the commission of the crime, the incomplete justifying or incomplete exempting shall be considered as a privilege mitigating circumstance. Second rule, if less than a majority of the elements necessary to justify the act or to exempt the offender from criminal liability attended the commission of the crime, the incomplete justifying or incomplete exempting shall be treated only as an ordinary mitigating circumstance. Third rule, if there are only 2 elements necessary to justify the act or 2 elements necessary to exempt the offender from criminal liability, the presence of one shall be considered already as majority. Hence, the incomplete justifying or incomplete exempting shall be treated as a privilege mitigating circumstance. Last rule, in case of incomplete self-defense, incomplete defense of a relative, incomplete defense of a stranger, there must always be unlawful aggression. If only the element of unlawful aggression is present, then the incomplete self-defense shall be treated as an ordinary mitigating circumstance. If aside from unlawful aggression, another element is present, then the incomplete self-defense shall be treated as a privilege mitigating circumstance. During the promulgation of judgment, or after posting his bail, the said accused jumped bail. He already went into hiding. So trial on the merits ensued in absentia. After trial on the merits, the judge found the accused guilty beyond reasonable doubt. No appeal. The judgment became final and executory. A warrant of arrest was issued by the court against the said accused, who went into hiding. The police officers were armed with this warrant of arrest. the PNP, the chief PNP officer of the said town, formed a group of 5 police officers and gave them the instruction, here is the warrant of arrest issued by the court against this person of X. Your duty is to locate this person and to bring him to this police station so that we could present him to the court and that he could be made to serve his sentence. That was the instruction given by the chief PNP of the town to the said police officers, a group of 5, headed by Police Officer A. And so armed with this warrant of arrest, this group of police officers looked for him. After searching, looking for him for several months, they finally got a tip from an informant that X was in this particular town. They went to the said place. When they arrived at the said place, they saw X talking with other persons. He was seated on a bench and he was talking with other persons. And this group of 5 police officers went to X. Based on the picture, he is that of X. And so the police officers served the warrant of arrest to X, who was then sitting at the bench. Upon reading the warrant of arrest, X hurriedly ran away from the said place. The head of this police officer A, pulled out his pistol and gave 5 shots on X, who was at the time running. 2 of the shots hit the head that caused the death of X. Later, the police officer who fired at the said accused was charged with a crime of homicide. His defense, according to him, he acted in the due performance of his duty, a justifying circumstance. Second, according to him, he acted in obedience to an order issued by his superior officer. Are these justifying circumstances present? Did the said police officer acted in the due performance of his duty? Did the said police officer act in obedience to an order issued by his superior? If these justifying circumstances are absent, is there at least incomplete justifying circumstance of fulfillment of duty or incomplete justifying circumstance of obedience to a lawful order? Insofar as fulfillment of duty as a justifying circumstance is concerned, there are only 2 elements. First element, that the offender acted in the due performance of his duty. Police Officer A was acting in the performance of his duty when he went there and he served the warrant of arrest. So the first element is present. The second element, that the resulting felony is the unavoidable consequence of the due performance of his duty. The second element is absent. The act of Police Officer A firing at X 5 times, 2 shots on the head, fatal that causes death, cannot be said to be the unavoidable consequence of the due performance of his duty. A single shot on the leg would suffice to prevent him from running. But giving him 5 shots, 2 fatal on the head, that would be no longer within the performance of his duty. There are 2 elements. The first is present, the second is absent. Although there is no justifying circumstance of fulfillment of duty, there is incomplete justifying circumstance of fulfillment of duty. And it is considered as a privilege mitigating circumstance because one is considered already as majority if there are only 2 elements. How about obedience to a lawful order? That an order was issued by a superior. The chief PNP issued the order. Second, the order must be lawful. It was lawful. By virtue of the warrant of arrest, you have to arrest X so that we can bring X to the court and make him serve the sentence imposed on him. It was a lawful order. The third element, the means used by Police Officer A to carry out the order is unlawful. The third element is absent because it is necessary that the means used by the subordinate must be lawful. But here, the means used by Police Officer A was unlawful. That is, firing at the said person of X 5 times. So there are three elements. Of the three elements, two are present, therefore, majority is present. Hence, it is also considered as a privilege mitigating circumstance. So in this case, Police Officer A should be convicted of the crime charge of homicide. However, he will be given two privilege mitigating circumstances of incomplete fulfillment of duty and also incomplete obedience to a lawful order, which are both privilege mitigating circumstances. Then we have the second mitigating circumstance, that the offender is under 18 years of age or over 70 years of age. So, if the said offender is 15 or below, it is exempted. If the said offender, however, is over 15 but below 18 years of age, and he acted with discernment, it is no longer exempting, it is a privilege mitigating circumstance. If minority is not exempting under Article 12, minority is always and always a privilege mitigating circumstance. So if the minor who is charged in court is over 15 but below 18, acting with discernment, the penalty to be imposed on him shall always consider the privilege mitigating circumstance of minority. That means the penalty to be imposed shall always be lowered by 1 degree based on Article 68 of the Revised Penal Code. So it shall always be lowered. It is a privilege mitigating circumstance. Being over 70 years of age or seniority is an ordinary mitigating circumstance. Therefore, it can be offset by any generic aggravating circumstance. Then we have the third mitigating circumstance. The third mitigating circumstance, that the offender has no intention to commit so grave a wrong as that committed. We have discussed this in Article 4, first paragraph. This is otherwise known as praeter intentionem. Then we have the fourth mitigating circumstance, that sufficient provocation or threat on the part of the offended party immediately preceded. Under the fourth mitigating circumstance, the elements are first, that there be threat or sufficient provocation. Second, this threat or sufficient provocation must originate from the offended party. And lastly, the said threat or sufficient provocation must be immediate to the commission of the crime. So there must be a threat, there must be sufficient provocation, and this must originate only from the victim, the offended party. If the said threat, if the said provocation would come from a third person, this mitigating circumstance would not lie in favor of the accused. So it is necessary that it must come only from the victim. And the third element requires that the commission of the crime must be immediate to the said provocation, to the said threat. When the law used the word immediate in the fourth mitigating circumstance, the word immediate here does not allow a lapse of time. It is necessary that right after the provocation coming from the victim, the accused would have already performed the said act. He was provoked to do it, and he performed the said criminal act. For this mitigating circumstance to lie in favor of the accused. So there must be no lapse of time between the provocation and the commission of the said criminal act. Related to this is the fifth mitigating circumstance, that the act was committed in immediate vindication of a grave offense to the one committing the felony, his spouse, ascendants, descendants, legitimate, natural, or adopted brothers or sisters or relatives by affinity in the same degree. The elements of the mitigating circumstance of immediate vindication of a grave offense are first, that there be a grave offense done to the one committing the felony or his relatives, spouse, ascendants, etc. And second, that the commission of this grave offense must be immediate to the commission of the crime. In other words, the commission of the said grave offense was the proximate cause of the commission of the crime by the offender. The word grave offense in the fifth mitigating circumstance refers to any act that would cause the offender tension, sleepless nights, and would move him to vindicate himself and the members of his family. The law does not require that it be a punishable act. It suffices that it cause the said offender restlessness and move him to vindicate himself. The second element requires that the commission of the crime must be immediate to the commission of the grave offense. The word immediate here this time allows a lapse of time. There may be a lapse of time between the commission of the crime and the commission of the grave offense. Because, according to the Supreme Court, it suffices that the said grave offense is the proximate cause of the commission of the crime. So here, the word immediate allows a lapse of time. And related to that is the sixth mitigating circumstance, that of having acted upon an impulse so powerful as naturally to have produced passion and obfuscation. So this is sudden impulse of passion and obfuscation. And the elements of this mitigating circumstance of sudden impulse of passion and obfuscation, first, that there be an act both unlawful and sufficient to produce passion and obfuscation on the part of the accused. And lastly, that the commission of the crime must not be far removed from the commission of this act that produced passion and obfuscation, sufficient for the victim to recover his normal equanimity. So based on the first element, it is necessary that there is an unlawful act done on the accused. And because of this unlawful act, there was passion and obfuscation in his part. Therefore, the said passion and obfuscation on the part of the accused must arise from lawful sentiments, because an unlawful act had been done against him. The second element requires again, it must be done immediately. Right after the act that has produced the passion and obfuscation, he must have already committed the crime. He must commit the crime before he recovers his normal equanimity. Otherwise, this mitigating circumstance would not reduce his imposable penalty. The husband and the wife were about to sleep when there was this voice from the outside and a banging on their door. It was their neighbor calling the name of the husband. They know the voice of the neighbor, and the said neighbor was calling on the name of the husband, telling the husband to get out. So what the wife did, the wife opened the door. He wanted to inquire from the neighbor what was the matter. But the moment the wife opened the door, the neighbor tried to hack her. But she was able to quickly close again the door, so she was not hit. The said neighbor was not satisfied. He kept on banging the door. And so the husband got out of the house by passing through the window in the kitchen. Outside, he confronted the neighbor and asked the neighbor what was the matter, why he was so mad, and why did he try to hit the wife. Without answering the question of the husband, the neighbor ran towards the husband with the said weapon, bolo, in a hacking position. He intended to hack the husband, but both of them struggled for the possession of the bolo, and the husband, once in possession of the bolo, hacked the neighbor. Then, he brought the neighbor to the hospital. The neighbor survived. The husband is now prosecuted for attempted homicide. And the husband invoked the following defenses so as to lower the imposable penalty. First, according to the said husband, there was sufficient provocation. Second, according to him, he was acting in immediate vindication of a grave offense. Third, according to him, he acted based on sudden impulse of passion and obfuscation. So he invokes three mitigating circumstances. Was there sufficient provocation? The act done by the neighbor was sufficient to move the husband to commit a wrongful act. The neighbor was banging the door. The neighbor tried to hack the wife. And this provocation came from the said offended party. And it was immediate. The commission of the crime, the hacking was immediate to the provocation. Therefore, sufficient provocation as a mitigating circumstance is present. How about immediate vindication of a grave offense? The act done by the neighbor trying to hack the wife, that constituted grave offense. And it was sufficient to move him to vindicate. And it was also done immediately. Therefore, immediate vindication of a grave offense as a mitigating circumstance is also present. How about sudden impulse of passion obfuscation? The said act of the neighbor trying to hack the wife and continuously hacking and banging the door of the house. These are unlawful acts that produce passion obfuscation on the said husband, that cause him to commit the said crime without having recovered his normal equanimity. All the elements are present. The act was done based on sudden impulse of passion and obfuscation. So these three mitigating circumstances attended the commission of the crime. If you were the judge, would you consider all three mitigating circumstances? If you were the judge, since these three mitigating circumstances arose from the same facts and circumstances, they shall be considered only as one mitigating circumstance in computing the penalty. Supreme Court said, when paragraphs 4, 5, and 6 are all attendant, or even two of them, let's say paragraph 5 and 6, or paragraph 4 and 5, or paragraph 4 and 6, if they are in attendant and they arose from the same facts and circumstances, they shall be treated only as one mitigating circumstance. Not as three, but only as one mitigating circumstance. The husband learned that the wife was having an affair. The wife confessed that she has another man. They got separated. After 2 weeks of separation, the husband looked for this other man. He found the other man in the public market. From a distance, he fired at that other man. That man died. The husband was prosecuted for murder. And one of the defenses that he raised, so as to lower the imposable penalty according to him, he acted in immediate vindication of a grave offense and based on sudden impulse of passion and obfuscation. Are these mitigating circumstances present? These mitigating circumstances are both absent. Supreme Court said, 2 weeks is too long a time for the said accused to have recovered his normal equanimity. Therefore, it cannot be said that the act of killing took place in immediate vindication of a grave offense or based on sudden impulse of passion and obfuscation. What if the husband learned that his grandfather tried to molest his wife? 4 days thereafter, he went to the house of the grandfather, and thereafter he fired a shot at the said grandfather. The said Lolo died, and X was prosecuted for the crime of murder. The husband was prosecuted for murder. The husband said it was done in immediate vindication of a grave offense. Is this mitigating circumstance present? Again, Supreme Court said, 4 days is already a long time for the offender to have recovered his normal equanimity. Therefore, it cannot be said that the said act of killing took place in immediate vindication of a grave offense. Hence, it was not considered. X, Y, and Z were all were co-workers. One time after their work, they have this drinking spree. And while they were having this drinking spree, X bullied Y. he would always say bad words and negative things about Y. And so Y confronted X. Why is it that whenever you're drunk, you would always say these words on me? They have a heated argument. The heated argument ensued into a fight between X and Y. Y was a small man. He was losing the fight. But he was able to give one lucky punch on X, on the jaw. And it was because of that one lucky punch, X fell on the ground, unconscious. He was brought to the hospital. The following morning, he went back home. But since then, he had already been having this headache, recurring headache every day, painful on the head. And so, he would go to the hospital. But since they had no money, he would also go back home. He was told to stay in the hospital for further examination, but since the family had no money, X would always go home. Until one time, because of severe pain on the head, X was brought to the hospital, but he expired in the hospital. And so, because of this, the said the person of Y was charged with a crime of homicide. And Y, however, invoked that he has no intention to kill the victim. He only gave one punch. And he never thought it would thereafter cause the headache and cause death. And second, according to him, there was sufficient provocation that came from the said victim. And likewise, according to him, it was only done based on sudden impulse of passion and obfuscation. If you were the court, how would you rule on the defense of lack of criminal intent to kill? How about on the mitigating circumstances that Y raised? Insofar as lack of criminal intent to kill is concerned, the said lack of criminal intent would not lie in favor of the accused. Since the victim died, it becomes a general criminal intent, which is presumed by law. And here, the said act of landing one lucky punch was the proximate cause of the said death. Therefore, he has to be liable for homicide. But if you were the court, if you were the judge, would you give him the mitigating circumstances that he was raising? Was there sufficient provocation? Supreme Court said yes, there was sufficient provocation. There was sufficient provocation because remember, they were having a drinking spree, and X had been stating bad words, bullying Y. There was a provocation coming from Y, and what ensued was only a heated altercation. It was only after the heated altercation that it ensued into a fight. But based on the said provocation, there was a heated argument. So it was appreciated by the Supreme Court. How about immediate vindication? About sudden impulse of passion obfuscation? Supreme Court also appreciated sudden impulse of passion and obfuscation. There was sudden impulse of passion obfuscation because the said act of saying bad words, threatening words, bullying words, disgust, action and obfuscation produce passion obfuscation on the part of the said accused that caused the said heated altercation. So, the said accused was convicted as charged, but these mitigating circumstances, since they arose from the same facts and circumstances, were considered by the court. Another mitigating circumstance considered by the court was voluntary surrender in paragraph 7 of Article 13. Under Article 13, paragraph 7, we have the mitigating circumstance that the offender had voluntarily surrendered himself to a person in authority or agent of person in authority, or that he has voluntarily confessed his guilt before the court prior to the presentation of the evidence for the prosecution. So based on paragraph 7, we have two mitigating circumstances. We have voluntary surrender, and the other one is voluntary plea of guilt. The elements of voluntary surrender as a mitigating circumstance are first, that the offender has not been actually arrested. Second, that he surrendered to a person in authority or an agent of person in authority. And third, that the said surrender is voluntary in nature. So the first element requires that the said offender, the said accused, has not yet been actually arrested. The police officers had not yet gone out to arrest him. Second element, he surrendered to a person in authority, the governor, the mayor. To an agent of person in authority, the police officers. Third element, the surrender is voluntary in nature. Surrender is said to be voluntary in nature when it is done spontaneously and unconditionally. It is said to be done spontaneously and unconditionally when the offender, in making the said surrender, wanted to confess his guilt, or he wanted to save the government, the funds, and efforts that they will incur in looking for him. Surrender is said to be voluntary in nature. The other mitigating circumstance in paragraph 7 is voluntary plea of guilt. The elements of voluntary plea of guilt are first, that the offender confesses his guilt spontaneously and unconditionally. Second, the confession of guilt must be done in open court. And third, the confession of guilt must be done before the presentation of the evidence for the prosecution. The first element requires that the confession of guilt must be done spontaneously and unconditionally. For the said confession of guilt to have been said to be done spontaneously, it must be to the original crime charge. If it is not on the original crime charge, then the plea of guilt is not done spontaneously. It will not mitigate the criminal liability of the said offender. So what if the accused was charged with the crime of murder? The accused, during pre-trial, moved and prayed to the court based on plea bargaining that he be rearraigned so that he could plead guilty to the lesser crime of homicide. And so, with the consent of the court, with the consent of the public prosecutor, and the consent of the heirs of the victim, the private complainants, the said accused was rearraigned, and he pleaded guilty to the crime of homicide. The judge rendered its decision. In its decision convicting the accused of homicide, the judge did not consider his voluntary plea of guilt so as to reduce the imposable penalty. Is the judge correct? The judge is correct because the plea of guilt was not done spontaneously. It was not on the original crime charge, but to a lesser crime based on a valid plea bargaining agreement. But what if the accused was charged as a principal in the crime of robbery? During arraignment, he pleaded not guilty. On pre-trial, on plea bargaining, he moved and prayed to the court that he be allowed to plead guilty to that of being a mere accomplice to the crime of robbery. The judge agreed, the public prosecutor consented, the private complainant consented. And so X was rearraigned, this time as an accomplice in the crime of robbery. The judge rendered its decision convicting the accused based on his plea of guilt. But the judge, in imposing the penalty, did not consider confession of guilt as a mitigating circumstance. Voluntary plea of guilt as a mitigating circumstance. Is the judge correct? Again, the judge is correct. Because I said confession of guilt cannot be considered as a mitigating circumstance because it was not done unconditionally. It was subject to the condition that he be a mere accomplice instead of what has been alleged in the original information, that of being a principal. And for that, the confession of guilt or the voluntary plea of guilt cannot be considered so as to reduce the imposable penalty. A case of estafa was filed against X before the office of the public prosecutor. After preliminary investigation, after considering all the documentary pieces of evidence, the public prosecutor found probable cause. And so the public prosecutor filed a case before the proper court. The judge found probable cause. And so the judge issued a warrant of arrest against X. X has a friend in the court. X is the friend of the court stenographer. And so when this friend learned that a warrant of arrest against X has already been signed by the judge and was about to be released, this court stenographer immediately called X and told X that the warrant of arrest against him had already been signed by the judge and would soon be transmitted to the police. Upon learning that, X immediately went to the police station and gave himself up. Thereafter, X posted bail. After trial on the merits, X was convicted as charged of the crime of estafa. But the judge did not consider his act of surrendering as voluntary surrender that would mitigate his criminal liability. The judge reasoned, there is already a warrant of arrest, therefore, your surrender is no longer considered as a mitigating circumstance. Is the judge correct? The judge is wrong. Even if there is already a warrant of arrest issued against the accused, for as long as the accused has not yet been arrested by the police officers, for as long as the police officers has not yet gone out to look for him and serve the warrant of arrest, and he immediately went to the police, that is still voluntary surrender, which is mitigating in nature. Therefore, the said judge was correct in not considering his voluntary surrender so as to reduce the imposable penalty. X entered the subdivision. The guard went up to X, and they were having an argument to X, telling X to get out of the subdivision. Because of the commotion between X and the guard, the police officers passing by stopped. The police officer asked him what was the issue. They immediately noticed something bulging on the waist of X. And they told X to lift his shirt. When X lifted the shirt, they saw a pistol tacked on the waist of X. The police officer asked X for the license and the permit to carry, the registration of the said pistol. But X could not produce any, and so X was brought to the police station. And thereafter, he was charged with illegal possession of loose firearms. X knew he could not produce any license, any permit to carry, because the truth is, the gun was unregistered. And so, on arraignment, hoping that his plea of guilt would reduce his imposable penalty, he immediately pleaded guilty to the charge of illegal possession of loose firearms. However, in rendering its judgment, the judge did not consider his voluntary plea of guilt as mitigating that would reduce the imposable penalty on X. Is the judge correct? The judge is correct. Illegal possession of loose firearms is punished by special penal law, RA 10591. Since it is punished by special penal law, therefore, you do not consider modifying circumstances such as mitigating circumstances unless the special penal law provides otherwise. And this special penal law doesn't provide otherwise, therefore, the judge did not consider this mitigating circumstance of voluntary plea of guilt. X was driving his car. While X was driving his car, he was feeling sleepy. He worked overtime, and it was already past 1 o'clock. And so he was driving the car recklessly until he hit a pedestrian who was crossing the street. Upon seeing that he hit someone on the said street, afraid of what the people would do to him. X left the said victim and went home. The following morning, he was watching the television, and on national television, he saw the incident, the act that he had done. The victim died. The victim that he hit died. No one knows that he was the driver of the said car that hit and killed the victim. There was no CCTV camera in the place. No one saw his car. No one saw him. However, he was bothered by his conscience, and so X went to the police. X told the police he was the one who hit and killed the said victim. According to him, he was so sorry for what he had done, and he is surrendering. And after that, he posted bail, and he was charged in court. During arraignment, he immediately pleaded guilty to the crime charge, reckless imprudence resulting in homicide. And so the judge rendered its decision. In its decision, convicting the accused of reckless imprudence resulting in homicide, the judge did not consider the mitigating circumstances of voluntary surrender and voluntary plea of guilt. Is the judge correct? The judge is correct. The crime charge is a culpable felony, a quasi-offense under Article 365. In the case of People versus Mariano, the Supreme Court said, in case of quasi-offenses under Article 365, the law expressly provides that courts need not consider modifying circumstances because under Article 365, courts are not mandated to apply Article 64 in the imposition of the penalties. Article 64 of the Revised Penal Code provides for the rules for the application of divisible penalties. So, since Article 365 itself provides that courts are not mandated to consider the rules under Article 64, which provides for the application of mitigating and aggravating circumstances, then it is correct for the judge not to appreciate these two mitigating circumstances. In other words, in case of quasi-offenses, it depends on the sound discretion of the court whether to consider modifying circumstances or not. Because the law expressly provides that they need not consider Article 64 of the Revised Penal Code. The eighth mitigating circumstance, that the offender is deaf and dumb, blind, or otherwise suffering some physical defect which thus restricts his means of defense and communication with his fellow beings. This is otherwise known as physical defect. For physical defect to be considered as a mitigating circumstance, it is necessary that it must have a relation, a connection to the crime that the offender has committed, such that the said physical defect has restricted his means of action, defense, or communication with his fellow beings. If the said physical defect has nothing to do with the crime that he has committed, it did not restrict his means of action, defense, or communication with his fellow being, then it cannot be considered as a mitigating circumstance. The ninth mitigating circumstance, such illness of the offender as would diminish the exercise of the willpower of the offender without, however, depriving him of consciousness of his acts. So it is necessary that the illness of the offender would only diminish the exercise of his willpower, but it must not totally make him unconscious of his act. Otherwise, if the said illness will make him unconscious of his acts, then it is not really mitigating, it is an exempting circumstance. X was driving his car recklessly, and he was driving the car recklessly because he was feeling dizzy, he was not feeling well. This is the result of the volume that he had taken based on the advice of the doctor for the sickness as a treatment for his sickness. So, while he was driving this car, recklessly, feeling dizzy, he hit and bumped a pedestrian. And the said pedestrian died, and so he was charged with reckless imprudence resulting in homicide. So as to lower his imposable penalty, he said that he had taken this volume, and because of this, according to him, he was feeling dizzy, and he has no control of his car. And so by reason thereof, he hit and killed this pedestrian. And according to him, it diminishes the exercise of his willpower, without, however, depriving him of consciousness of his act. He is conscious, however, it diminishes his willpower. Will this mitigating circumstance lie in his favor? The mitigating circumstance will lie in his favor. It will not exempt him from criminal liability, but it will mitigate his criminal liability. It diminishes the exercise. He is conscious of what he's doing, but it diminishes the exercise of his willpower. The last mitigating circumstance, any other circumstance similar in nature and analogous, those mentioned from paragraphs 1 to paragraph 9. The public officer was charged with a crime of malversation. The amount that he collected, he malversed the same. And since he was charged with malversation, he borrowed money from other people and restituted the entire amount to the state, to the authorities. What is the effect of such restitution on his criminal liability? It will serve as a mitigating circumstance. It is akin to voluntary surrender. So what if this public officer, he was charged with malversation, and he restituted the entire amount. Not only that, he immediately surrendered himself. After trial on the merits, you as the judge convicted him. What mitigating circumstances would you consider? You have to consider two mitigating circumstances. One is the actual voluntary surrender. He gave himself up to the authorities. And the other one is the restitution, which is akin to voluntary surrender. What if the accused was charged, he was a former mayor, and based on investigation, he failed to render an accounting. And because of this, he was charged in court. He immediately restituted the amount. What is the effect of such restitution on his criminal liability? In the case of Lumawig versus People, the Supreme Court said that if in the crime of malversation, restitution is considered as akin to voluntary surrender, as analogous to voluntary surrender, in failure to render an accounting under Article 218, it is also considered as akin to voluntary surrender. So, not only in malversation, but in any other crimes, under Title 7, crimes committed by public officer, wherein there is restitution, it can be considered as akin to voluntary surrender. Then we go to aggravating circumstances. Under Article 14, we have aggravating circumstances. Aggravating circumstances are those circumstances which, if present or attendant in the commission of a felony, would serve to increase the imposable penalty without however going beyond the maximum penalty prescribed by law. So the penalty that can be imposed must not go beyond the maximum penalty prescribed by law. No matter how many aggravating circumstances attended the commission of the crime, the court cannot impose a penalty beyond the maximum penalty prescribed by law. That is the limit. There are different kinds of aggravating circumstances. First, we have the so-called generic aggravating circumstances. They are those which apply to all kinds of crimes. An example of this is recidivism. Recidivism applies to all kinds of crimes. Then we have the so-called specific aggravating circumstances. those which apply to certain or particular crimes. For example, we have cruelty. Cruelty applies only to crimes against persons. You cannot consider cruelty in crimes against property, in crimes committed by public officers, only in crimes against persons. Then we have inherent aggravating circumstances, those which of necessity accompany the commission of the crime. They are considered as ingredient elements in the commission of the crime. Hence, even if they are proven, they are no longer considered so as to increase the imposable penalty because they are absorbed. Then we have special aggravating circumstances, those which provides for the imposition of the maximum penalty prescribed by law. Hence, it cannot be offset by any mitigating circumstance. Example of a special aggravating circumstance: if the crime is committed by a syndicate or organized crime group, under Article 62, the maximum penalty prescribed by law shall be the one imposed. Therefore, being a member of a syndicate or organized crime group means the imposition of the penalty shall be the maximum penalty. It cannot be offset by any mitigating circumstance. It is a special aggravating circumstance. And then we have the last one is the qualifying aggravating circumstances. Those which change the nature of the crime to bring about a more serious crime with a higher penalty, or even without changing the nature of the crime, it brings about the imposition of a higher penalty. Examples of qualifying aggravating circumstances, those enumerated in the crime of murder under Article 248. Any of those circumstances would qualify a killing. Instead of the offender being charged with the crime of homicide, he will be charged with the crime of murder. They change the nature of the killing from homicide to murder to bring about a more serious crime with a higher penalty. From reclusion temporal, it will be reclusion perpetua to death. So those are the different aggravating circumstances. We have again generic, we have specific, we have inherent, we have special, and we have qualifying aggravating circumstances. Whatever be the kind of aggravating circumstances, for it to be considered by the court, it must be both alleged in the information and proven during trial. If it is not alleged in the information, even if it is proven during trial, it cannot be considered by the court. Even if it is alleged in the information but not proven during trial, it cannot be considered by the court. So aggravating circumstances must be both alleged in the information and proven during trial beyond reasonable doubt for it to be considered by the court. Otherwise, you will be depriving the accused to be informed of the nature of the cause of accusation against him. Insofar as qualifying circumstances are concerned, you only need one qualifying circumstance to be considered in order to qualify, let's say, a killing from homicide to murder. If there are other qualifying circumstances present, they shall only be considered as generic aggravating circumstances. So X killed the victim. X killed the victim with treachery because he was paid by Y. And he killed the victim by the use of a motor vehicle. So all of these were alleged in the information that the accused killed the victim with treachery, and it was done by means of a motor vehicle, and also it was done in consideration of a price reward or promise. These were alleged and proven during trial. You were the judge convicting the accused. How would you appreciate these circumstances present? You have to convict the accused of the crime of murder qualified by treachery. And the use of the motor vehicle and also in consideration of a price reward promise shall be considered only as generic aggravating circumstances. What is the effect? The crime charge is murder. qualified by treachery, therefore the penalty would be reclusion perpetua. But there are two aggravating circumstances which are generic, therefore the maximum period of the penalty shall be imposed, it should be death penalty. What if the accused was charged with a crime of murder and the information alleged that the killing was done both with treachery and abuse of superior strength? These two qualifying circumstances were both alleged in the information and proven during trial. If you were the judge convicting the accused, how would you consider these aggravating circumstances? You have to convict the accused of the crime of murder qualified by treachery, and the abuse of superior strength is absorbed in the crime of treachery, in the aggravating circumstance of treachery. Supreme Court said, it is settled in jurisprudence that when both treachery and abuse of superior strength attended the commission of the crime, treachery absorbs abuse of superior strength. Therefore, the abuse of superior strength shall no longer be considered as a generic aggravating circumstance. It is simply absorbed. We go to the different aggravating circumstance under Article 14. The first aggravating circumstance under Article 14, that advantage be taken by the offender of his public position. The offender, who is definitely a public officer, is deemed to have taken advantage of his public position when the said public officer misuse and abuse his public position in order to commit the crime or to facilitate the commission of the crime. Here the public officer makes use of the influence, the ascendancy, and the prestige that his office affords him in order to facilitate the commission of the crime. What kind of aggravating circumstance is taking advantage of one's public position? Under Article 14, it is a generic aggravating circumstance. However, if you look under Article 62 as amended by RA 7659, it is a special aggravating circumstance. Under Article 62, as amended by RA 7659, if the crime is committed by a public officer taking advantage of his public position, the maximum period of the penalty prescribed by law shall be the one imposed. Therefore, it is a special aggravating circumstance which cannot be offset by any mitigating circumstance. The police officer was assigned in this area along España. All jeepney drivers who are flying this route, at 6 o'clock in the morning, the police officer was already there, must give to him a tong in the amount of 100 pesos. No tong, they could not fly the said route. They are obligated. Otherwise, they cannot have their business of driving the said jeepney. One time, one of the jeepney drivers got mad at this police officer. Enough is enough. Every day, we are giving him 100 pesos. And so he filed a case before the Office of the Public Prosecutor against this police officer for robbery, extortion. Every day they would give money to him because of the intimidation. And in the information, the fiscal found probable cause, and in the information for robbery, the fiscal said that the act of robbery was committed by the said accused police officer by taking advantage of his public position. It was alleged in the information, it was proven during trial. Were it not for the fact that he was a police officer, these jeepney drivers would not be intimidated and would not give the 100 pesos tong. Alleged and proven. If you were the judge convicting the accused, how would you consider this aggravating circumstance? As I said, it shall be considered as a special aggravating circumstance. Therefore, the maximum penalty for simple robbery shall be the one imposed, and this taking advantage of one's public position cannot be offset by any mitigating circumstance. Then we have the second aggravating circumstance, that the crime be committed in contempt of or with insult to public authorities. The elements of this aggravating circumstance are first, that a public authority was engaged in the performance of his function. Second, that he is not the person against whom the crime is committed. Third, that the offender knows him to be a public authority. And fourth, his presence did not prevent the offender from committing the crime. These are the elements of in contempt of or with insult to public authorities. First element, it is necessary that a public authority must perform this function, but the second element requires he is not the person against whom the crime is committed. Therefore, he must not be the victim. Because if he is the victim, the crime committed is direct assault, and in case of direct assault, in contempt of or with insult to public authority is inherent. Because the very essence of direct assault is lack of respect to public authority. So it is necessary that he must not be the victim. The third element requires the offender, the accused, knows him to be a public authority. And despite knowledge that there is a public authority present, that knowledge, that presence of the public authority did not deter him, did not prevent the accused, the offender, from committing the crime. Hence, his crime will be aggravated by these aggravating circumstances. The barangay chairman and the wife went to the public market. They went to the meat section. They were buying some meat. Here comes X and Y, a constituent of the said barangay chairman. X and Y, upon seeing the said barangay chairman, greeted the said barangay chairman as well as the wife. Thereafter, they went to the next meat section, just beside the place where the chairman was buying meat. And there, on the pretext that they were buying meat, X and Y went on both sides of one of the people in the said public market by the name of Z. While Z was busy looking which meat to buy, X and Y were also busy trying to get the wallet inside the pocket of Z. And they were successful in getting the wallet, but the police officer passing by saw it and they were arrested. And so they were charged with the crime of theft. In the information, it was alleged that the said act was committed in contempt of or with insult to public authority because it was done in the presence of the said barangay chairman. Is this aggravating circumstance present so as to increase the imposable penalty? The first element requires a public authority was engaged in the performance of his function. The barangay chairman is a public authority, but at the time of the commission of the crime of theft, he was not in the performance of his public function. The barangay chairman was performing a private act with the act buying some food, buying some meat in the public market. The first element being absent, therefore it cannot be said that the crime was committed in contempt of or with insult to public authorities. But what if these two persons, A and B, were having this altercation near the store? When they were having this altercation near the store, a person passed by. That person was the mayor of the place. X and Y were not from this barangay. They were strangers to this barangay. They just went by to the said store to buy cigarettes. But later on, there was this altercation between both of them. They were already shouting at each other when the mayor of the place passed by together with two bodyguards. The mayor went to these two persons, X and Y, and introduced himself as the mayor of the place. And X and Y didn't mind the mayor. Although the mayor introduced that he was the head of the place, the mayor of the place, X and Y continued with the said altercation until both bodyguards of the mayor held the hands of X and Y and told them, the mayor is talking to you. And that is the only time they stopped. And the mayor told them that they should stop their argument. They should go to their respective destination. And so both of them stopped. However, when X was about to leave, Y pulled out something from his back pocket, a knife, opened it, and thereafter stabbed X at the back in the presence of the mayor. X was immediately brought to the hospital. It was a non-fatal wound, while was prosecuted for attempted homicide. In the information, it was alleged that the crime was committed in contempt of or with insult to public authorities. Is this aggravating circumstance in attendance? First element, the public authority was in the performance of his function. The mayor was performing his function when he was trying to pacify X and Y to maintain peace and order. Second, he is not the victim. He is not the person against whom the crime is committed. And the offender, Y, knows him to be a public authority. He introduced himself. The bodyguards even told him that the mayor is talking to them. Therefore, Y knew he was a public authority engaged in the performance of his function. Last element, the presence of the mayor did not prevent Y from committing the act of stabbing X. Therefore, Y should be convicted of the crime of attempted homicide with the aggravating circumstance of in contempt of or with insult to public authorities. Then we have the third aggravating circumstance, that the act be committed with insult or in disregard of the respect due the offended party on account of his rank, age, or sex, or that it be committed in the dwelling of the offended party if the latter has not given provocation. Under the third paragraph, we have four aggravating circumstances. We have disregard of rank, disregard of age, disregard of sex. And we have also the crime committed inside the dwelling of the said offended party. Disregard of rank, disregard of age, and disregard of sex can only be committed or can only be appreciated. These aggravating circumstances can only be appreciated in crimes against persons, Title 8, and in crimes against honor, Title 13. You do not appreciate disregard of rank, disregard of age, and disregard of sex in any other crimes, but Title 8, crimes against persons, homicide, murder, physical injuries, and Title 13, crimes against honor, libel, slander, oral defamation, intriguing against honor. That is only in these two kinds of crimes. There is disregard of rank when the offended party is of a higher position in society and than that of the offender, and the offender did not consider the said high rank, high standing in society of the said victim in the commission of the crime. There is disregard of age when the offender did not consider or disrespected the minor age or the senior age of the victim. And there is disregard of sex when the offender disregarded, disrespected the womanhood of the said victim. Disregard of rank, age, or sex can be appreciated by the court collectively or individually, depending on their presence and nature in the commission of the crime. Dwelling is considered as an aggravating circumstance if the crime is committed inside the dwelling of the said victim. Dwelling refers to any building or structure used for rest or comfort. In the Constitution, in the Bill of Rights, provides for the so-called respect or the right to privacy of one's abode. Hence, if the crime is committed in the dwelling of the victim, it shows that the offender disrespected the privacy of the dwelling, the privacy of one's abode. That's why it is considered as an aggravating circumstance. Even if the crime is committed inside the dwelling of the victim, dwelling is not considered as an aggravating circumstance in the following instances. First, if the victim had given provocation. Second, if both the victim and the accused are living in the same dwelling. Or, if dwelling is considered as an element in the commission of the crime. Under these three circumstances, even if the crime is committed inside the dwelling of the victim, dwelling is not considered as an aggravating circumstance. Insofar as dwelling as an aggravating circumstance is concerned, you do not consider ownership of the dwelling. Even if the said victim is not the owner of the said dwelling, for as long as he used the said place for rest and comfort, then it is considered as an aggravating circumstance if he is killed, if he is committed with any crime inside the said dwelling. Last bar, there was this problem. There are actually many aggravating circumstances as there, but we are not yet on the other aggravating circumstances. We are still on dwelling. And the problem was that the mayor, the judge convicted the said accused. On appeal, the said accused escaped. And the said accused looked for the judge. And the accused learned that every Saturday and Sunday, the judge is in the house of the mistress. And so the accused waited for the judge in the house of the mistress that Saturday night. And when the said accused knew that the judge was already in the house of the mistress, the said accused went inside and found the judge and the mistress having coffee. Thereafter, the said accused stabbed the judge to death. There was a question on direct assault. There was a question on quasi-recidivism, different aggravating circumstances. But one of the aggravating circumstances asked is the aggravating circumstance of dwelling present? The aggravating circumstance of dwelling is present. It is not required that you be killed in your own house. Ownership is immaterial. During Saturdays and Sundays, this judge used this place for his rest and comfort. Therefore, during Saturdays and Sundays, this is his dwelling. And since he was killed inside the dwelling, then dwelling will be considered as an aggravating circumstance. What if, in the same problem, while the judge was having coffee inside the said dwelling with the mistress, they went to the window, and X, from the outside, fired a shot at the judge. The judge died. Is the aggravating circumstance of dwelling present? The aggravating circumstance of dwelling is present. Supreme Court said, it is not necessary that the accused enter the dwelling of the victim. It suffices that the crime was committed inside the dwelling and the victim was in the dwelling, even if the crime was perpetrated from the outside by the said accused. Dwelling is still considered as an aggravating circumstance. I will stop there. I will continue with paragraph 4 tomorrow.